Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont versus Brittany Knight, case number 24AP212. Representing the appellant, Brittany Knight, is Don Matthews. Representing the appellee, the State of Vermont, is Evan Meenan.
Thanks very much, and good morning, counsel. We'll hear from counsel for the appellant first, of course. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors. I'm Dawn Matthews, and I'm representing Brittany Knight.
Thank you.
This court must reverse the trial court's restitution order in this matter for two reasons. First, Ms. Knight had a due process right to be present at a critical stage of her trial, and she did not waive it. Second, without any testimony from Ms. Westcomb, the state could not and did not establish the stringent causal link necessary to demonstrate that the conduct leading to Ms. Knight's misdemeanor conviction resulted in the damage to her eyeglasses or dentures. If the court does not have any particular questions for me, I'm happy to reserve the rest of my time for rebuttal.
Okay, that's fine. I don't see any hands, so we'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont. First and foremost, I'd like to thank the court for granting the state's motion for oral argument. And consistent with that motion, there's only two things that I would like to address this morning. The first is a mistaken attribution of a comment by the state to the trial court. The state acknowledges, and I personally apologize for stating on page 8 of my brief that the court said something when in fact it was the state. The comment was, quote, Ms. Knight had the ability to be here. She chose not to be here. There's no continuance requested. According to the transcript, the state clearly said that and the court did not. And I apologize for not being able to provide an adequate explanation for that misattribution. However, it is the state's position that that misattribution does not mean that the court erred in holding the restitution hearing in appellant's absence. The statement that was misattributed was made on 15 lines into the substantive portion of the transcript. Before that statement was made, the court put on the record that the defendant was absent from the hearing and that it was a work-related absence. And then following that comment, the state made the misattributed statement, and that statement, while the court did not adopt it as specifically adopted as findings, the statement does accurately reflect several things that were established by the record, including that restitution hearings are part of sentencing. Appellant was initially present for the sentencing. The court told the appellant the date and time when the sentencing would be continued to address restitution. The appellant voluntarily absented herself from the hearing in order to go to work, and neither she nor her counsel requested a continuance. For reasons analogous to this court's decision in Stanley, which is discussed on pages 15 and 16 of the state's brief, those facts are sufficient to show that the appellant waived her right to be present at the restitution hearing. The second thing that I would like to address is the summary of the charging affidavit in the state's brief. The state's statement of facts starts out with a recitation of the charges and the allegations from the information and affidavit of probable cause. The allegations from the affidavit are clearly labeled as such in the state's brief to avoid any confusion as to whether or not they were admitted at either the change of plea or the restitution hearing. The reason why the state summarized the affidavit is because an understanding of the differences between the evidence supporting the allegations and the evidence admitted at the change of plea and the restitution hearing is helpful in determining whether or not the latter evidence was missing any key information. On page 20 of the state's brief, which is in the argument section, the state outlines the evidence that it asserts was sufficient to support the restitution judgment order, and all of that evidence was admitted at the change of plea and the restitution hearing. It includes things such as the appellant was convicted of committing domestic assault against her mother, Miss Westcomb. The appellant committed this offense by punching Miss Westcomb in the face 3 times. Victims advocate Rooney was assigned to help Miss Westcomb obtain relief for the injuries she sustained as a result of that particular action. And in providing this assistance, Ms. Rooney followed the Victims' Compensation Program's process for ensuring that any losses it advanced were statutorily authorized. In addition, Ms. Rooney obtained itemized receipts for Westcom's losses directly from the dentist and the eye doctor, and Ms. Rooney paid for those receipts directly. That's the evidence that was summarized on page 20. In preparing for oral argument this morning, I noticed an additional piece of evidence from the change of plea hearing that also supports the causal connection between appellant's crime and the restitution judgment order.
You have 1 minute.
Thank you.
You have 1 minute. Thank you.
That additional fact is at the change of plea hearing, the appellant agreed it was suspected that Ms. Westcom's nose was broken. The statement she agreed to specifically was she wasn't sure if her nose was broken or not. Thank you once again for granting the state's motion for oral argument, and absent any questions, that completes my comments this morning. Thank you.
I don't see any hands, and thank you for your disclosure, Mr. Meenan. So we'll turn back to the appellant. How much time does the appellant have, please?
Appellant has 4 minutes and 11 seconds remaining.
All right, counsel.
Not a case where presence of the defendant would have been useless or the benefit but a shadow. This is not a case where there was any waiver. There was not. This is analogous to State v. Grace and should be controlled by State v. Grace. Ms. Knight's attorney didn't ask for a continuance, nor did the attorney in State v. Grace. And there was no written waiver of her desire to be present. Secondly,
Ms. Matthews, what's in this context, what is different as far as the outcome between a written waiver and voluntarily absenting oneself from a hearing that they were given notice of?
well, we don't have any. If it was a written waiver, there would be at least a presumption that somewhere within the written waiver, counsel had gone over with her client the reason why she would want to be there, that there were factual issues that needed to be determined, and there would have been, it would be clear that it was her choice not to come and not to contest those. And the court would need that kind of knowledge and and explanation and an assertion that it happened, and there just wasn't here. The fact is that the court said there, it seems to be a work-related absence, and then the court said something along the lines of, Ms. Davis has tried to reach her client and can't, and that simply doesn't get to the presumption that the state wants to get to, which is that she knew about this and she didn't care and didn't wish to go because she had nothing to say.
I'm sorry, wasn't she given notice though? It seems to me that that comment that you are attributing to her attorney was something more relevant to what was going on that day, that she couldn't contact her. But didn't she get notice well before that of the hearing?
Well, she was told she certainly was told at the change of plea hearing that it would be scheduled for 2 weeks and they would do it at 1 o'clock. It's not in the record that she received any other notice than the court telling her that it would be done 2 weeks from then at 1 o'clock. So,
but you're not making an argument that there was no notice.
No, she was in court that day. I'm not making an argument that there was no notice. I'm saying there was no written notice and there was no evidence put on the record at the restitution hearing that her not being there was voluntary and knowing, nor that, as Grace suggests, nor that she understood why her presence might be necessary to dispute facts. Those things I do not think you can draw from either the change of plea hearing or from the representations that her attorney made.
Okay, thank you.
And then the next part is that simply—
You have 1 minute, counsel, 1 minute.
Sure, and simply because the victim's advocate got receipts that showed that the complainant had dental work and eyeglass repair work done we can't assume that because at a change of plea, where, by the way, this judge who ordered restitution was not actually the person who took the change of plea. And although there wasn't a dispute that she said she punched her mother and she was sorry for that, there's just no connection to the there's no connection except for the court's surmise that led to these injuries. And that's not what this court has ever said about establishing a stringent causal link between the damage and the actions. They needed something more and they didn't have it.
Okay, your time has expired. Thank you both. Please